This is Michael Popok, Legal AF. We've got a lot to talk about. We got Donald Trump now suing his trial judge, Judge Engoron in New York State Supreme Court, presiding over and would handle the what we call bench trial involving the $250 million civil fraud case brought by the New York Attorney General against Donald Trump and 16 others in his organization, which would result in him getting effectively the corporate death penalty in New York, never being able to be an officer or director of a New York corporation and losing probably more than $250 million. We have a big development. Donald Trump couldn't get Judge Engoron disqualified. He can't get a jury trial because it's too late. His lawyer, Lalina Haba, screwed that up a year and a half ago. And now he's stuck with Judge Engoron going to trial in 19 days on October the 2nd. They've asked for a delay from the trial judge Engoron just recently to have him wait at least 3 weeks beyond October 2nd or more for him to be able to consider some summary judgment motion papers that they had filed, arguing to the judge that most of the case is outside the statute of limitations, therefore too stale, too old to be tried. It's based on a ruling by the same First Department Appellate Division, the first level appellate court in New York, in Manhattan, that ruled in June, sort of in favor of Donald Trump, that certain of his transactions can't be the basis of the civil fraud case because they're too old. They're outside the 6-year statute of limitations. That's why Ivanka Trump is no longer in the case, because while she was involved so long ago that it's beyond the 6-year statute of limitations. Donald Trump has argued now today in his filing that already got ruled upon about 3 hours after it was filed, argued to the appellate court in an emergency petition under an arcane aspect of New York law called Article 78, which I'm going to talk to you about in a minute, that the judge is going off the rails. The judge is doing illegal things, they're arguing. That the trial judge isn't following the mandate, the direction of the appellate court about which transactions are in or out. Now, that's not entirely true. The trial judge who's also handling the summary judgments that are pending and is also handling the trial, it's not like there's a jury that needs to be protected from information, has said in due course in the next few days, he will decide which transactions can be put up in evidence in the case by the New York Attorney General, and which cannot. He'll use a razor blade supplied to him by the First Department, and he'll cut the case. He hasn't done it yet, but he will. He'll also rule on the summary judgments in due course. Donald Trump didn't like that. He filed an order to show cause to have the judge delay the trial by 3 weeks. The judge denied it without merit. They took that piece of paper, they wrapped it into what's called an Article 78 petition, which is usually used by someone to appeal a decision by a local government, state, municipality, and the like, when you don't like the decision they made. You didn't get the license or the permit you wanted. You didn't get the zoning decision. You take an Article 78 appeal, effectively an appeal from an administrative agency, up to a trial judge. What you don't do generally is sue the trial judge with Article 78 and bring it up to his bosses at the appellate division. But that's what Donald Trump did. And it was assigned to Justice Friedman. And Justice Friedman, listen, frankly, didn't waste any time, called an immediate hearing later this afternoon, just this past, in the last hour or so. It was attended by lawyers for the court system that are now representing Judge Engoron because he was sued in his official capacity. Lawyers for Letitia James were on there as well. And the lawyers for Donald Trump were on. And this judge, kind of similar to the shadow docket we talk a lot about on Legal AF in the Supreme Court setting, is sort of the gatekeeper. He decides whether to make the decision on his own, to either grant the petition, to order Judge Engoron to do something. I mean, the ask, I always tell my lawyers when I train them, judges want to know two things when you're in front of them, and you got to do it quickly. Why are you here, and what do you want? The what do you want part apparently is they want Judge Engoron to delay the trial, to give him more time to consider the summary judgments, which he's going to have to consider, and make a decision now about which transactions are inside and outside the statute of limitations before they have to go to trial and prepare. That's what they're asking for. The justice that's handling this one justice, Justice Friedman, really the issue for him was, should he stay any aspect of the trial court level, right? Any of the proceedings, put a pin in it, right? As of today, the 14th of September, to give the appellate court, the full appellate court, all 5 judges, not just Justice Friedman. It won't be Justice Friedman. It'll be 5 judges on a panel. The time to fully brief, even on an expedited basis, this issue of whether an Article 78 petition should or should not be used in this setting, if it can be used to force a judge who has wide discretion to set every aspect of a trial. Generally, it's not reversible error. It's not even appealable during the case itself. What you do is, if you're a normal defendant, and Donald Trump is not, you take your lumps from decisions you don't like, you try your case, and if you lose, you preserve these errors that you claim the trial judge made on appeal. You take your appeal, you argue that they are reversible errors, ones that should actually vacate the decision and send it back for another trial. And that's what you do. But we're not Donald Trump. Donald Trump doesn't like these kind of intermediary decisions that are being made by the trial judge on issues that he has broad discretion to make about the trial setting and how to run his courtroom, and wants the appellate panel to force him to do something. I'm just confused as to what he's forcing them to do. The judge said he is going to follow the mandate of the appellate division from their June decision and use his razor, his scalpel, to cut the case and cut out claims that are time barred, that aren't allowed under the ruling. So their argument that he's rogue, he's illegal, he's not making the decision, we don't know what trial we're trying, we don't know what case we're trying, and that prejudices us. I mean, that I don't think is going to go over well with the full panel of the First Department Appellate Division, of which I am a member. I'm a member of that bar. But in the meantime, this poor justice just has to decide, should he just put a pin temporarily, hold the ring, as we like to say, at the lower level with Judge Engoron to give his colleagues a full merits panel who's going to decide the merits, time to fully brief and decide what they want to do. So he sort of did what a lot of judges in this circumstance do. They punt and they go, we'll grant a temporary stay. Doesn't mean the ultimate trial date is going to move. It really now depends on how quickly the full appellate panel that's assigned to the case, randomly, all 5, we'll see who they are, generally very democratic, are going to set a briefing schedule and how fast. I assume it's going to go fast. It's going to go quickly. Could the October date slip a little bit? Maybe. But I don't think we should go into panic mode. I know the headlines that are going to be all over the media are, Trump wins big, stops trial. Not quite. He's got an intermediary, preliminary, temporary ruling that for a short period of time, the trial judge needs to kind of stop, right? We hit the clock and stop the clock from running down below while the appellate court makes its ultimate decision. Now we got to wait to see what the appellate court on full briefing and how fast of an expedited calendar they're going to go. The Attorney General obviously is asking for, we got to do this fast. We got, because of the checkerboard of 7 trials in 9 months for Donald Trump around the country, criminal and state, we got to get this one in. October is perfect because the next one is not until March or May. That's her argument. Let's get a fast briefing, get all this done within a week and make the decision. We'll see what the appellate court does, First Department. If they go normal track, this case is delayed 3 to 6 months. If they go expedited track, we could get a ruling by next week. So stay tuned here on the MeidasTouch Legal AF channel and on YouTube's just like this one. Free subscribe to the MeidasTouch YouTube channel. Help get them to 2 million. They're so exquisitely close to getting to 2 million subscribers. Help them get there. And follow me, Michael Popok, along with my co-anchors on Legal AF, also on the MeidasTouch network at the intersection of law and politics. Give me a thumbs up for this video. And until my next hot take, this is Michael Popok, Legal AF.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.